Welcome to the second part of the lecture. As in the first part, we had discussion about how access to justice can be linked to the emergence or incorporation of alternative dispute resolution in the context of Bangladesh. So in this part, we will try to explain what is our understanding about access to justice. Access to justice means access to formal adjudicative process in the court system or access to litigation. In broader sense, access to justice implies any form of justice delivered to individuals. UNDP, this is one of the patron organ within the United Nations, defined access to justice as the ability of people from disadvantaged groups to prevent and overcome human poverty by seeking and obtaining a remedy through the justice system for grievances in accordance with human rights principles and standards. What we see here is that in the UNDP definition, it mostly emphasized to the disadvantaged people, and disadvantaged people means the people who lives below the poverty line, who are marginalized, who lacks facilities in the society, and because of their vulnerability, they cannot access to the available state mechanisms in terms of facilities, and judiciary is one of those mechanism. But certainly, this group of people are deprived. So, as per the UNDP is concerned, it's more focused on the people who are disadvantages. Access to justice is associated with the ability to bring a grievance before court, including the right to a fair hearing and an effective remedy. So, if you look at this definition by MacBridge, he highlighted that access to justice is something including ability to bring a dispute before the court, and that also include the procedural aspects within the court, which implies the right to a fair hearing. So that is also part of access to justice and an effective remedy. So the right to access the court, while not specifically mentioned in international human rights law, has become an increasingly explicit over time through case-based standard setting. What the author tries to highlight here is that access to justice has become a vital demand of the human society in 21st century, particularly in the court access. International Council of Human Rights Policy has provided a definition that includes the ability to report domestic violence to the police with the expectation that action will be taken, protection from corruption, crime and violence, as well as access to basic services like education, health, water, and sanitation. They also recognized that both state and non-state mechanisms can and should be used to improve access to rights. So basically, the Human Rights Policy Council has given a wider definition. I don't think that is exactly relevant to our purposes, but there are some themes provided here which I think is quite important for our understanding and explanations. Now, the question is that within a society, within a situation where we have densest population, having around at least 18 crore population, if they want to avail the opportunity of the court premise, how far that is going to be pragmatically feasible in the context of the existing setup and mechanism provided in the country. So the ratio and the number of judges, court facilities, whether that can actually provide minimal basic facility for every citizen to reach the courtyard. And that's a serious question I think we need to ask ourselves. And when we are going to find that, I guess we will have uh, an assessment about whether we are really in a position to facilitate those. It is revealed that the number of judges and other officials, as well as the availability of physical facilities, has remained insufficient. More than 3 million cases are pending with the lower courts across the country. And on top of that, more than 3.3 million are pending in the higher courts, are pending in both higher and lower courts, 3.3 million. Of these, 2.8 million cases are pending with the lower courts. No, yeah, sorry, 3 million pending in the lower courts, and I think around more than 4 lakh are in the High Court division. So that's what the figure is, the number is saying. The issue here is that it is stated that around close to 1 million cases are pending for last 5 years, and that is what the important point is, that within the range of 5 years, if 1 million, I mean it's 9 lakh around cases remain pending in the courts, then it is quite concerning whether and how far the court is going to resolve the disputes. Now, here actually I'd like to request you to give your own thinking, and that is looking at these statistics, what we see is that apparently it seems that the state is not moving ahead in terms of resolving the disputes, because the number of pending suits and cases are quite large, and hence we highlight that. I mean, what our point here is that in such situation, let's assume another 5 years from today and think about whether the existing facilities will be able to solve the disputes or not. If around 9 lakh is pending in last 5 years, what will be the number in next 5 years? And that is a serious question I think we should ask to ourselves. And we cannot actually get out of this the way it is being reflected. Here comes to the rule of alternative dispute resolution. So I mean, that's the point what I would like to make. When ADR mechanism is being inaugurated, let's say in next 5 years, if there are 5 to 10 lakh cases to be pending before the court, and if all of the cases are given and suits are given an opportunity to go for alternative dispute resolutions, assuming and be sure that at least 10% of the disputes will be solved through the alternative dispute mechanism. And that is where actually the whole argument lies. I mean, if we can solve 10% of the dispute through alternative dispute resolutions, that is the success of ADR. And that is what we are trying to argue in this case. So please understand that when I am referring to the statistics and numbers, my point is that under the existing regular adversarial mechanisms, it is not possible to continue with the suits to solve it with the proportionate timing because of the facilities and the infrastructures available as well as the resources available. On the other hand, the way new issues are emerging, courts are experiencing new kind of disputes. So the way the nature of the disputes are being expanded, the numbers of the dispute are also extending. It will be getting large and large by the time. And therefore, it is important for us to highlight here that the ADR mechanism should focus on resolving the disputes through alternative measures, and that will actually play a complementary role to the main adversarial system in ensuring access to justice. So this is what the whole nexus and connectivity in it. I hope you all understand that. Thank you very much. Sorry, just please understand that there is a nexus between these numbers of disputes pending and then the capacity of the state in ordinary process to resolve, and then the possibility of resolving disputes through ADR, and then how that complements to ensuring access to justice. So thank you very much.